Thank you so much. Thanks for inviting me. I am really, really pleased and honored to be joined by two luminaries, two of the most important people at the USPTO that keep the place running. And I think I sort of see my job as getting out of the way and hearing from you two. So on my far left is Peter Ayers. Peter Ayers joined the USPTO Solicitor's Office as Senior Counsel in 2020 after more than 25 years in private practice. So his primary responsibility at the office, in the solicitor's office, is to oversee the director's involvement in appeals to the Federal Circuit, in appeals to the Federal Circuit from the PTAB. He also represents the office in Federal Circuit ex parte and inter partes cases, and in 145 actions at the district court. Peter has a Bachelor of Science in Electrical Engineering from Washington State, a Master's in Electrical Engineering and Computer Science from Stanford, and a JD from Northwestern. And after law school, Peter clerked for Judge Frazier. Judge Range is to my immediate left and is an administrative patent judge or an APJ at the PTAB, where he served for over 6 years. He presides on panels for IPRs and has authored over 500 ex parte appeal decisions. For 15 years before joining the PTO, he was an IP litigator at firms like Cincinnati and Brobeck. He received his law degree from Harvard and his BS from another large state Texas institution. One other thing that I should say, both of them are employed by the USPTO, but they are here in their personal capacity. Nothing that they say represents the agency or the administration, but rather their personal individual views. I thought maybe we'd start with some opening statements, some opening remarks. Peter, do you want to kick us off?
Yeah, thank you. Well, first thing, thank you for having me. I did want to make sure, if you were here to see the solicitor of the Patent and Trademark Office, you've come to the wrong place. I am not the solicitor, and I may not even be senior counsel after he finds out that I'm advertising myself or holding myself out as the solicitor. But I guess sort of on that point, as the professor said, I recently joined the patent office after spending most of my career in private practice, predominantly here in Austin. But started out as a law clerk for a judge on the Federal Circuit, so it's kind of come full circle now, 25 years later. And I just kind of want to put, as I have you as my captive audience, I just kind of want to put a plug in for government service. I mean, I'm so fortunate to be in the position I am and to do the work that I do. I just don't know that there's any other job in America that would allow me to do the variety of things that I do. As was mentioned, I represent the director at the Federal Circuit, so I do appeals. I represent the office in district court in 145 actions. I also, was just on a call with the Office of the Solicitor General, developing our position in response to calls for views of the Solicitor General in patent cases. So I help kind of formulate our positions on, all these cases that you read about coming out of the Federal Circuit or coming out of the Supreme Court. So I understand, there's a big financial sacrifice in serving for the government. So it certainly helps if you've made a lot of money, like I have, before you go into government service. And also marrying well, I think, helps. So, I also recommend that too. I'm fortunate in that regard. But yeah, I just wanted to kind of, while I have you here, just kind of put a plug in. If you don't know what you want to do, to think about a judicial clerkship in particular. And also, jobs at DOJ, whether it's in the honors program or in our office, although we tend to hire off of judicial clerkships primarily. So with that, I'll turn it over to Adrian.
Yeah, just echo Peter's thoughts. The most important thing is to marry well. Not financially, but just do that. But I've been with the PTAB for 6 years now. I love it. A couple of things I love about it is the one thing Peter mentioned is the variety. Hearing Miss King speak about doing her patent case for 9 years is bringing back flashbacks of my litigation life. And I promise she was not working on only that case for 9 years. So there is some variety, but in contrast, if I'm doing ex parte appeals, I'm writing 7 to 12 decisions per month, and I'm conferencing and editing another 14 or so, right? And so that's, instead of just doing one patent for 9 years, it's 21 patents. So it's a different pace, more technology, more quickly. So I really enjoyed that.
There you go.
Oh,
We'll be outside.
the other thing I wanted to mention is that I think the government gets a bad rap as being inefficient in a lot of areas, and I see some of that in government. Like, for example, the logistics that are required for me to be allowed to speak here, which is kind of unbelievable. But in terms of us actually deciding things, it's incredibly efficient. And like my metrics is just like how much can I get done is really what matters, which is kind of a breath of fresh air from a law firm metric, which is just how long can you work on something else. So that's also a nice thing about government job.
I'm just going to echo that call too.
Very well.
Very well. But also public service. I love my job as a professor. It's a great job, but my most satisfying jobs in the legal career have been jobs that have had a public service element, and I think it's just been fantastic. But we're not here to talk about that. We're going to talk about the office and the patent office. And so I thought we might start with Arthrex. So start with the end of the Supreme Court's term last year. So some, namely me, have described Arthrex as restructuring the patent office. So it restructures the design of the patent office in a way that sort of subordinates, not to speak ill of you, Judge Reid, but subordinates the PTAB, this board of expert technical adjudicators, to the policy judgments of the agency's political leadership. And Peter, maybe I'll start with you. Maybe you can tell me a little bit, or tell us a little bit about whether that's right? What has Arthrex changed about the office or the structure of the office on the day-to-day basis? Has it had any effect on your work? Does it change the way we should think about the office?
Yeah, well, it certainly did change it. For those of you who aren't familiar with the Arthrex decision, it's a decision of the Supreme Court, which basically said that the patent office judges, the APJs, couldn't render a final written decision invalidating the patent without someone without the director being involved in that decision. That because of their power to declare something invalid, that was a power that was exercisable only with supervision by a so-called principal officer, someone who's appointed by the president and nominated by the president and confirmed by the Senate. And that's essentially what the Federal Circuit had decided. And their remedy, their fix for that was to remove the civil service protections for judges like Judge Range, which I'm sure he was concerned about, allowing the director to fire those APJs at will, essentially, if he didn't like the outcome in any particular case, presumably. I think the Supreme Court thought that was a little bit of a draconian remedy. And so what they said was instead that, there has to be some kind of appeal mechanism, some supervision or oversight of the final decisions by the director. And so in response to that, we created this process for director review. And this is on our website, and we have Q&As that kind of describe how that process goes. So I refer you to that as sort of the definitive source on the process itself. And now an aggrieved party can ask for director review following a final decision in AIA proceeding. And so certainly in that sense, there has been a restructuring of it. I don't know that it has fundamentally changed and sort of re-altered the balance of powers within the PTO. If you think sort of, I think kind of practically, well, I guess I would say that I don't think, maybe your premise is wrong, is that most of these decisions, in fact, I would say virtually all of them are not policy driven. These are fact-bound decisions about, what the prior art teaches, what the patent claims, and by and large, there's really no policy that needs to be decided. There certainly are policy decisions that the director makes, that the board, I think, tries to faithfully execute, but the vast majority of final written decisions out of the PTAB are fact-bound decisions that, don't really move the needle on policy issues.
This may not be a fair question, we really didn't ask you to come up with these numbers, but I wonder if you just happen to know what, so you said the vast majority of these tend to not have policy. Have we seen any appeals to the director so far?
Yeah, we've seen quite a few, actually.
Yeah, and
I mean, I don't know exactly, but I mean, there were a bunch of decisions that were up on appeal at the federal circuit and were held pending the Arthrex decision. Those all kind of were remanded to the patent office on Moss, and the patent office has done a really good job kind of largely working through those. And the vast majority of those requests for director review were denied. There have been a couple where they were granted, but it is sort of the rare, exception rather than the rule. I don't have the exact statistics. Someone surely does. So.
Okay, thanks. I sort of speaking of sort of day-to-day work, Judge Ray, I wonder, maybe you want to talk a little bit about the process of the PTAB and what makes for a good presentation before the agency. And given the range of stuff that you see, maybe we can break it down into 3 categories. First, in the context of ex parte appeals, what makes for a good ex parte presentation, and what makes for good prosecution, so you don't even have to get to that stage. Second, in the context of IPR, what's effective on the merits, and then also what's effective at the institution stage.
Yes, great questions. First, just to follow up on Arthrex, just from my perspective, it doesn't really change my life. I'm going to decide the same thing. If the director wants to do something different, that's what the director is going to do. It's got almost nothing to do with me at that point, similar to the way the federal circuit would affect me. Just they'll do what they're going to do. I just do the best I can. I love the question about ex parte appeals. So most of my work in my first 4 years or so, I did tons of ex parte appeals. And now I have more of a mixed docket. An ex parte appeal is when the examiner rejects the claims of a patent application. The person who applied doesn't like the examiner's decision, so they appeal. Panel 3, PTAB judges gets the appeal. That's an ex parte appeal. So this is a patent that hasn't issued yet. And you first ask what people can do in prosecution before the examiner to be better when they come to me, or maybe avoid coming to me. 2 things I can think of. One is really strive for clarity of patent claims. One unfortunate thing that happens sometimes is an examiner will reject a patent application based on prior art, and it comes to us, and we don't understand what the claim means, which is a Section 112 issue. And we have the power to issue new grounds that the examiner didn't, new grounds for rejection that the examiner didn't do. That's discretionary. It's one of the few things we have discretion on. But this is one of the few circumstances where we will exercise that discretion, because we can't compare prior art to something we don't understand. It's just not it's just not possible, right? So I'd say be clear in prosecution. The second point, which sort of relates to that, is this happens both ex partes and in IPRs, where the two sides are arguing about whether or not prior art applies to a patent claim. And the argument inherently involves claim construction, what the claim means, right? But sometimes neither party is actually arguing claim construction. They're just sort of assuming in their mind it means this, and they're going about their business of making the argument without being explicit about it. In the ex parte context, that can be particularly unfortunate because we're going to read the claims, provide the context for the specification, right? But not reading particular embodiments into the claims. And that's a line drawing exercise that can be difficult, right? But if you have a particular embodiment in your specification and you want your claim to cover that, then if you can use the words to actually do that before getting to me, that's much better than arguing about, well, I wrote something broader, but I really mean this more narrow thing that's in this spec. Like, just, you know, if you're happy enough with the narrow claim, just write it that way in the first place, and you can avoid this whole problem. And then also AIA tips.
Yes, and also the AIA.
Yes. So on the IPRs, I'd really strive for clarity of presentation. I think one way you can get there is look at high dollar IPRs. There are some people that are doing extraordinarily good work on IPRs on both sides, both petitioners and patent owners. And their work is good because it's very logical and easy to follow in terms of how it's structured, right? And so if I pick up a petition and I've got to go claim by claim, element by element, and see if the prior art teaches or suggests each element, right? So please, for the love of God, write your brief that way, right? Like, don't be like, oh, well, here's 3 prior references and they teach all these different things, and here's the claim and it's the same. Like, no, do my work for me, please. The first claim element, here's where the prior teaches it. Second claim element, here's where the prior teaches it. A lot of people do a great job. They do it that way. Not everyone does. Flip side, the patent owner only has to shoot down, you know, one claim element of the independent claims, right? So if you can have a focused argument as to why the art doesn't teach one claim element, then great, go for that. But again, that's going to be a lot more effective than just kind of a mishmash of art references and cross-referencing different parts of your brief. Don't cross-reference. I mean, sometimes you have to a little, but it's just such a pain.
And what about an institution? So what gets an IPR or a petition for IPR past the institution stage?
Well, there's 2 different things, right? There's the merits of it, which is what's this? Reasonable likelihood of prevailing on the merits at trial. This is standard. And on top of that, there's also the Administrative Procedures Act, right, which I always have to be aware of, which requires that anything the patent office does has to be sort of backed up by substantial evidence. So those are kind of the 2 standards I have in mind on the merits. And I think to a lot of us, the merits are important. Like I care a lot more about the merits than other things. That being said, we're also bound by an institution. FinTIB is a precedential decision for us. And something like FinTIB essentially says, hey, if the district court is going to be in trial way before you get to this or whatever, then let's not do an IPR if the district court's going to hear it first, put simply. And the director ultimately has total authority to whether or not IPRs, total discretion, right, into whether or not IPRs are instituted or not. I'm subject to Administrative Procedures Act, perhaps, but that's not really my issue. But that authority or discretion is delegated to us. As far as institution goes, what the director says via presidential decisions is what we're going to do.
So maybe I'll ask a little bit more about what's infinitive and what's not infinitive. So infinitive says some things about what's, so the status of the patent or the status of other district court litigation, but it also suggests that there's a sort of catch-all other factors. And so maybe you can tell us a little bit about what some of those other factors might be that might help us get over the hump, or help the petitioner get over the hump, maybe, if there's some infinitive factors that maybe cut against the petitioner.
Yeah, so if you're arguing fintive on either side.
Well, before, is everyone familiar with fintive? It seems like a kind of a nuance,
Yeah,
so maybe it'd be helpful to
Yeah, maybe I can
background on
grab the 5 factors, and I keep in mind that again, this is up to the director to some degree, and we've got a nominee for a new director that's not confirmed by the Senate yet, and things are always subject to change depending on how that goes. But for now, this is the status quo.
So, and just let maybe kind of set this, it's like, this is a situation where there's co-pending district court litigation and an IPR, and the board is deciding whether or not to institute the IPR, given that one of the overarching policies behind the AIA was to make patent litigation more efficient. And if there's parallel concurrent litigation on the same issues, that's not really fulfilling that policy goal. And so fintive is a precedential decision out of the board, which sort of sets some factors that the board should take into consideration when deciding whether to institute in light of concurrent litigation.
Yeah, appreciate that, Peter. So with that context in mind, the 6 things that the fintive asks us to look at is whether or not the district court has already stayed the case, or it's likely to stay the case. The second, when the trial court's trial date is relative to when we'll have a final written decision. By statute, we have 1 year to decide once we institute, and we always meet that deadline. That's a point of pride for us. Third, investment in the district court litigation that's already taken place. Fourth, to what extent there's overlap in issues. Fifth, whether or not the petitioner and the defendant in the district court are the same party. If they're different parties, then that will tend against declining institution. It gets tricky because there's a lot of negatives. It's kind of double and triple negatives. And then other circumstances. And you asked about other circumstances, which I think that a lot of practitioners arguing fintive, I would argue all the factors, sure, but also think about other circumstances, and in particular, what evidence you might have to prove up those other circumstances. Like, for example, I see in the press, people say, oh, IPRs are such a burden on us as a patent owner. Well, you could try making that argument as another circumstance and provide evidence as to, in your particular circumstance, is a particular burden, or vice versa. Petitioner might say, well, we invested so much in developing this IPR, it'd be really wasteful for it to just now not get instituted, and people could try making that case. Also, how does institution or non-instituting, how does that affect the public, right? That's not an enumerated factor, but there may be, maybe a petitioner could say, oh, well, the public's paying a lot more on a patent, they shouldn't have to pay, or patent owner might bill say, this is gonna diminish our ability to innovate in the future. Those all might be interesting arguments, but again, I'd say if you're going to make those kind of arguments, just saying it doesn't really I wouldn't think get you anywhere. You need evidence as to why this is the case, right? So I just urge people to be creative about it. I don't have any promise that it might be effective or not be effective, but might be worth thinking about.
Well, and I think one of the other factors that is explicitly mentioned is the merits, right?
Yes.
So obviously, the stronger the petition, the less likely the order's going to decline the institute. Back to your earlier question about Arthrex, obviously this analysis is infected with policy considerations, but it turns out that at the present time, institution decisions are not subject to director review. And so you can see a situation where like that might be a situation where, the director's policy considerations could come into play, but yet right now we don't allow for director review of institution decisions.
That's interesting. That's interesting to know. And then just to emphasize a little bit what you just said about the other circumstances. It would be interesting and clever, I think, to think about the presentation that you make along lines of other discretion in equitable context, because it sounds like a little bit of what you're saying is that there is this fourth public interest factor, just like when we're doing analysis for stay or preliminary injunctions. There's a wide amount of discretion, and what matters for that exercise of discretion are certainly the merits, as they do in stays and in other contexts, but also how much is this going to cost in terms of litigation? How much is this going to cost in terms of IPR? What are the sunk costs that we have? What are the public interest stakes? Is there a pressing public health emergency that requires us to look at this patent particularly closely?
Sure.
Those are the sorts of things that if you could tie them specifically to the patent at issue, they might matter. Again, I want to be super cautious.
Yeah, that's a tip I give in general. Is it's always helpful when advocating to tell a story, right? So that, instead of just being like, enumerate the factors, maybe there's a compelling story around this that can be told.
I want to come back, Peter, to what you said just a second ago about there not being director level review on institution. And sort of actually on the question of institution in general, the other thing that you said earlier on the policy goal behind the AIA being to promote efficient adjudication of patents, patent validity. And the fact that perhaps if we have two concurrent proceedings, one in the district court and one in the patent office, that would strike us as inefficient. And so we have some doctrinal tools to help us avoid that problem. You could decide to not institute, and that's what Tejas is all about. You could stay the district court litigation. And so, Peter, I wonder whether
we can't stay it, but
well, no, you can't stay it. The district court could stay the district. You might seek a stay of the district court litigation. You might, or a party might, right? And so maybe you can talk a little bit about, to the extent you can say. I'd be interested to know when you think district courts ought to stay litigation, or when you think the agency ought to decline to institute, knowing that some of that is governed by FinTIP. And so how we should think of, in particular, how should we think about these two parallel lanes as in relation to each other?
Well, I mean, to me, like, it all starts with Congress. I mean, Congress is the one who obviously created the Patent Act in the first instance, and creates these patent rights. And then it was Congress who came along later and passed the AIA, allowing parties to seek inter parties review or other proceedings to challenge the validity of an issued patent in this proceeding. So I think you have to start there from first principles. If you're going to consider, policy type arguments about, who is better situated to adjudicate any particular issue, I think, frankly, you have to consider the expertise of the institution. And, I've worked with a lot of patent judges in my position, and have appeared before many of them in private practice before that. And I've been just singularly impressed with their expertise, their dedication, and if you look at their track record at the Federal Circuit in terms of the results of those decisions and how they've been held, they've held up on appeal, I think you'd have to say that they're doing a very good job. I mean, sometimes, it seems like many of the reversals I see are on procedural grounds that, the board didn't, point to, substantial evidence, or was, they couldn't decide what the board was doing because they didn't articulate it very well. But by and large, I think the board does a very good job of adjudicating these issues of patentability based on printed publication. That is right in the patent office's wheelhouse. We do that every day, day in and day out. As Judge Raines mentioned, he's done it, 500 times. So, to me, it's sort of like, I think about it in terms of institutional expertise. Now, we were at dinner last night with Judge Albright. He's not in the audience, so I can say this, but I would say it even if he was here, but he told me that he's already had like 107 Markman hearings, right? And that's more. He issued more Markman decisions in the time he's been on the bench than the entire Northern District of California did in that same time period. So like he's obviously an expert in claim construction as well, right? And so I think you'd have to, give him the credit he's due in terms of the expertise that he brings to the bench, particularly when he's supported by, I think in almost all cases, technically trained, law clerks or special masters or technical advisors in that process. So I think you could certainly make a case that, he's got his, institutional expertise on that as well.
Judge Albright also defended the first deposition I ever took as a lawyer. So, yeah, he's been
around the block, and so I'm not here to sort of disparage his expertise in doing what he does, but the reality is that not every district court judge is Judge Albright. They don't come to the bench with deep patent litigation experience, and they may only see a few cases a year if over their entire career. And I think you have to think in those situations that now the balance really shifts in favor of the PTAB in terms of their relative expertise in deciding those cases. So, maybe that's something that, should be in one of these other factors. I mean, we do consider I don't, but I know the board takes into consideration, the average length of trial and the, docket congestion and things of that sort, but maybe you need to consider the expertise of the particular judge that you're before. Could be one of those other factors, for example. So I guess that's how I would sort of answer it. I would look at sort of the institutional advantages. The other thing is, like, in the PTAB really is the judge and jury, right? They decide the claim construction, and then they rule on the factual issues about what the prior art teaches. In contrast, of course, you have in Judge Albright's case in particular, you have someone who certainly has tremendous expertise in claim construction, but then we're going to ask a lay jury to decide those questions about, as Paul was saying, that juries work really hard, and I have tremendous faith in the work that they do, but, these issues are really complicated, and not every case sets up well for a jury to resolve these really complicated issues. And, again, I love our jury system, and I'm a big advocate, and I again, don't want to criticize the system that our founders created for handling, patent disputes. But again, I think that's something that should, go into the calculus in deciding, which is the appropriate forum to resolve a particular issue in patent cases.
So one thing I wanted to mention, the expertise from Professor Kumar's presentation earlier, she was saying that there's sometimes a mismatch between technology at issue and the PTAB judges assigned. And there is an effort made by, there's a paneling group, which is kind of a black box to me, but some human beings decide what judges will be on a panel, and it's based on who's available, but also subject matter expertise to some degree. And I think that it would be rare for a panel to have no one on it that has a degree or kind of official technical expertise in the area. I mean, there's only maybe people on the panel that, you know, like I'm chemical engineering degree, but I will be on AI electrical cases, but there's always someone on the panel who actually has an electrical degree or whatever, at least in my experience. I can't say that it might not ever happen, to the contrary, it could. I'd be interested in the stats, but they do try to match the technologies out there.
That relates to another question I wanted to ask, which was about if you could sort of conceive of expertise in two ways, where you have Judge Albright has a ton of expertise, and I'm sure, in patent law and patent procedure. But you also said he has to rely on advisors, technical advisors, when it comes to questions of the specifics of the technology. And eventually some of those questions—
I didn't say he has to, I said he does.
He does.
I think he has to, but, you know.
Yeah. I'll say he has to. He does, and the jury certainly relies on the expert witnesses. But Judge Ray, you just mentioned that you certainly also have a lot of expertise in patent law and patent procedure, but also, like by statute, you're all required to have a certain amount of technical expertise too. And so I guess one question I have is, how much does that substantive technical expertise actually matter? Do you find yourself drawing on that, or do you find you leaning on your panel members who have that in a particular IPR? And like, if you could imagine doing IPRs without the expertise, where you have to rely only on the presentations from others, do you think that that would be markedly worse, markedly better? Or is sort of trying to analogize what a fictitious IPR might look like that looks a bit more like what Judge Albright is doing?
So I think I don't, for Judge Albright in particular, I don't think I have any particular advantages over him. Even though his degree may not be technical, he's been doing technical patent work for a long time. And I found it interesting, again, Professor Kamar's presentation, she was talking about how there were 6 technical areas in Europe, and they tried to have like one electrical expert. In my experience, like having a PhD in electrical engineering doesn't necessarily provide you with expertise of the case before you, right? Because maybe your PhD's on a circuit design for a particular phone, and the electrical case is on cellular networks or how to modulate RF frequency, right? Like these things are entirely different things. And so at the examiner level, those examiners are highly specialized very often. I like to talk about an examiner I met who examines conveyor belt patents. All day, every day, patents on conveyor belts, last 20 years. Like, that is a specialty, right? But it's not practical to have a PTAB judge that's a conveyor belt specialist, let alone an Article 3 judge who's a conveyor belt specialist, right? And so I think to some degree, the technical background is helpful in the sense that I feel comfortable learning as I need to, right? Because science is some baseline, and I think just the more science you understand, the more you can understand other science as it's presented to you. So I think it's helpful in that way.
Let me also say that, you know, I think part of the problem is there's this huge disparity between the amount of resources that are committed to get the patent and then to invalidate the patent. And so the record that the Patent Office is dealing with in normal examination and the amount of effort that goes into building that record, while perhaps sufficient to issue the patent, it just pales in comparison to the amount of effort that private litigants spend developing that art and honing those arguments in whether in district court or in the IPR. And it seems like, if they're challenging the work product of the patent office, it seems only fair to give the patent office a chance to correct any errors that they made based on the work that's been invested in that. So I guess in terms, if I have to come down and make a hard choice, but, do I want this decided in the patent office or do I want this decided in the district court? Yeah, I guess I would favor deciding it in the PTAB.
That's great.
So.
I have a few more questions, but I also know that we are bumping up on almost 12 minutes left. So I want to make sure that if the audience has questions, we leave time for that too. I'm happy to keep going, but I also want to give the students and everyone else a chance to ask some questions.
I have a question. So, and I apologize, maybe you already touched on this, but for the benefit of a lot of the students here that do have technical degrees, when somebody comes up to argue before you and they do have a technical degree, does that bear on your decision at all? Does that lend more credibility, or do you not even care about something like that as long as it's presenting their argument?
I wouldn't even know. Yeah. But one thing I personally do is I intentionally don't try not to even pay attention to lawyers. Like we have conflicts, people make sure I don't have a conflict in the beginning, but then I try to forget. In fact, I even try and forget who the parties are to a case.
I always wanted to learn stuff.
Yeah. I mean, some people do, but I just think it's better if I just don't. I mean, obviously, if they're framing an oral argument, I'm going to see them. But yeah, it's not really relevant. Along those lines, one thing, even though we do have some technical expertise, as an advocate, I wouldn't assume too much, right? Like you're better off assuming that I know less than assuming that I know more, and then go from there, especially in the briefing. I think once it's an oral argument, at that point we've read the briefs, and if you wrote them well, we probably understand them. So that oral argument doesn't have to be quite as base level.
I would also say if you look at probably the luminaries in the Federal Circuit, certainly at the Supreme Court, they're not technical people. They're just kick-ass lawyers. So whether you have a technical background or not, it certainly is advantageous, particularly if you're practicing, I think, before the PTAB, because those cases really do turn on their facts. And you really need to understand that. And obviously, if you have a baseline understanding, that's going to allow you to understand that case at a deeper level. But once you get to the Federal Circuit, it's certainly the Supreme Court that those things sort of melt away.
One practice pointer is you can skip arguing basic patent law. That's like I know KSR. If people know that's not familiar, it's the Supreme Court case. It sets rules for obviousness. Yes, very familiar.
Any other question? Yeah. Go ahead.
Yeah, so I wonder, I don't know I don't have a great example of this, but I'm wondering to what extent there's communication with the PTAB about what may be recurrent issues, whether procedural issues or go across different areas, or just like connecting things to sort of smartphone activation or whatnot. So where sort of by looking at things on a case-by-case basis, but then seeing that there's sort of commonalities across cases, issues can be raised that maybe the director should be paying attention to this, should provide some guidance on this. We're struggling on this issue, or we're seeing examiners repeatedly dealing with applications where the only novel thing is now you're activating something using your smartphone or something, and maybe we need to provide the examiner the tools to try to analyze better whether that's obvious or not. Is there any of that kind of sort of upward communication as to issues that the director or someone else in the office should be looking to provide guidance on, or the director mainly just responding to things that sort of blow up at the, say, federal circuit or Supreme Court level?
I can take a crack at that. What I've observed, and obviously I don't have a lot of experience, but I have a lot of visibility into the director review process, for example, but that's a very formal mechanism that only applies to, as I said, the final written decisions in cases, so that's probably not. But from where I sit, it seems like we do a lot of outreach, whether it's, the chief APJ of the board or the director, that we are constantly receiving input from stakeholders, and I think by and large, are responsive to those, to that input. I can't comment on your particular situation.
I know I was making something up.
Yeah, but I think that there are a lot of avenues for stakeholder input on a whole range of issues and procedures, and it seems like if it's a concern to our stakeholders, that we're responsive to those concerns.
Yeah.
So.
Yeah, I think I was thinking the same thing. Also, I mean, keep in mind the director is managing this huge organization, right? There's 12,000 examiners, and so a big part of the job is just managing that. And I think what you're saying sort of would speak to one aspect of management, right? Like how can examiners do their job better? What kind of search tools can they use to?
Right. Well, yeah. I mean, I know certain companies like Toyota, have created mechanisms for people working on the assembly line to say, hey, we could need to improve this. This is like a stopping.
And those things are constantly being.
I know that there's like a patent advisory committee or something like that has members of the public and but again, I think there are these mechanisms that currently exist that elicit and
right. Well,
receive.
I'm looking again. I'm concerned more with the internal.
I think this is
like
I see. Are you talking that how examiners, for example, themselves could?
Right.
Oh, I see. Okay.
I've been seeing like what I've seen in the press. The prior director Yonku, I think there was some talk of interest in how can AI be used to better improve search algorithms of the examining court, right? Like that's kind of an interesting just efficiency issue, similar to how the CEO of Ford would be interested in that kind of thing, right? So there's definitely always trying to improve efficiency.
So I was wondering. Oh, I'm sorry.
Yeah. Oh, yeah.
No, go ahead. Students.
Okay.
So I'm a junior associate, so I'm still just learning how IPRs are working, really. But I'm curious about how to best add value with an expert declaration. When I looked at them, it seems like a lot of them are very, very similar to the brief. Almost like they are point for point support for the brief. And it seems like the whole idea of the PTAB is to be a more efficient form of dealing with all these things, but the expert brief a lot of times doesn't seem like it's adding, it's just a bunch of fluff. It's not fluff, but and so is there a way to actually make it useful and not just, oh, here's my cites for these points?
Yeah, that's a surprisingly tough question for me. I think that providing the cites might be important to people to some degree, just by itself, right? Because otherwise the other side will say, well, you didn't have evidence, right? And at least that provides some evidence. But then there's cases that say, well, if you're just merely parroting what the lawyers say, et cetera, then it doesn't have much weight. I think to the extent that the expert, this is more coming from when I was practicing more than when I was a judge, but I always felt like when an expert could sort of be themselves, I always kind of liked that. Like when I could hire an expert who actually was an expert and not just a guy who was willing to say whatever I said. And to the extent they can sort of provide that.
Suggesting that experts are shills for their lawyers?
Yeah. Not saying that, but not coming either way. But I think that there might be a place for an expert to expand on what's in the brief with their own personality and their own further explanation of why this is the case. And argument that's not in the brief might not necessarily count, so that's an issue. So it's complicated, and I really don't know how to answer that very well.
And maybe Paula, we've got a very experienced practitioner here who could probably bear it, but at least in my practice, one of the things I always wanted to do is to make sure that I got my expert to introduce the demonstratives. If you're gonna have, gonna do annotations, you're gonna do things like that that are gonna really be helpful in illustrating your case, is like use your experts to articulate that. And then obviously, as we talked about earlier, that when it comes to the motivation to combine, that's really where your expert's gonna earn her pay. Because it's sort of like, we've got to stitch this case together, and it's not maybe it's in the art in some form, but, really it's your expert who's going to bring all those pieces together. Do you have anything to add, Paula?
No, I agree with that. I think that, your expert is, that where they bring the most weight is because for an obviousness combination, your expert is the only person who's going to be able to make that statement. That the art can be combined. And so, but I think I hear you with respect to that the expert declarations look a lot like a petition, and from someone who practices and uses that, sometimes what happens is one gets written first, and then the other one follows, and so that does happen. But I think it is better to stay away from that kind of situation.
Another thing to be aware of is the expert also needs evidence, right? Like, a lot of times experts get criticized for, well, you said this, but there's no proof of that. So it's evidence upon evidence, right?
We'll take one more question. I know you have a.
Yeah, we've done. So I know that and this is sort of the credibility question that came up earlier. When the PTO goes before the Federal Circuit, the decision of the agency, not just the PTAB,
right,
tribunal, but the agency to intervene or to make to appear as an amicus, things like this. The decision to appear, and B, the sort of crafting of the position that you're going to end up taking. Whether you think this might be headed to the Supreme Court, you're going to have to deal with the SG at some point. Can you comment at all on sort of the way in which those internal policy choices and judgments, how do you sort of convene that discussion?
I mean, I think by and large, we want to reach the right result. And if we believe that the board has made an obvious error, we're not going to get up there and defend that. We're going to ask for a remand and, correct the mistake, because, our interest is in reaching the right and correct results based on the law and the facts. Then sort of as a matter of course, we see a lot of cases where and I'll just sort of give you the easy cases, where the one of the parties, the appellee, falls out, that they won below, and they're like, this is a slam dunk, we're not going to spend the money to defend this, or maybe the parties have settled and the appellee has no interest now in seeing this to finality. So we will, as a matter of course, intervene in those cases. If there's a constitutional issue raised, again, that's something that we will necessarily intervene in. I would say if it gets beyond sort of the typical kind of balls and strikes issues that involve the patent office and the merits of that decision, that the Department of Justice gets involved and that we coordinate with them. And certainly to the extent there's, constitutional issues, because these issues, whether, like in Arthrex, for example, what's a principal offer, what's a, inferior officer, what, that permeates across the federal government in the entire administrative state. So they are managing that government-wide. And then, of course, when and then there's some, it's not really a turf battle, but they'll typically argue those cases if it's if it's not right in our wheelhouse. We have civil appellate will handle those cases. And even had some cases where they've challenged, like in Mobility Works, they've said, oh, the PTAB judges compensation system creates a bias, and maybe you're involved in that case, and raises sort of due process concerns, even though that is sort of attacks the process, within our agency, that civil appellate will typically be involved in those too. And then anytime that there's calls for the views of the Solicitor General at the Supreme Court on a patent issue, will typically be involved in those and providing our input to the Solicitor General on our recommendation. But again, they have much bigger concerns. If we're arguing to overturn precedent and Roe v. Wade is hanging in the balance, okay, well, maybe we don't want to. We know that your little patent issue is really important, but we got bigger fish to fry here. So they have to weigh all those from a holistic federal perspective. So we provide our input, but ultimately they're the ones who make the call.
Other questions? We still have time?
As long as you want to keep going, we have an hour planned for lunch. I imagine that's plenty of time for people. So if you have something,
I'm happy to answer any questions, but also don't want to keep you from your lunch.
Well, I want to follow up on that question in particular, on the internal process, particularly when it comes to the Department of Justice and CDSGs. So it is obvious to me what the Patent Office's stakes are in cases presenting questions of patentability, for example, when it comes to obviousness or 101
Right.
or 112 or what have you. It is less obvious to me what your stakes are in cases that present questions about infringement, or cases that present questions about the process, the legal process that attends to infringement cases. And I wonder.
We just had a case like that, by the way.
I
All
know.
off suit. Are we involved in that?
I was not.
Okay.
But I know. So this is these recent cases are a little bit of what's informing the way I think about this. So I guess maybe without asking you to speak to any recent CDSGs, how do you think about developing the Patent Office's stakes in a case that's really just about infringement between two parties?
Well, and I'm heavily involved in these. I'm like now already in my third CDSG in a patent case, and
What's the CBSG?
it calls for the views of the Solicitor General when there's a cert petition filed at the Supreme Court, and they want the views of the government on it because it implicates some federal issue, often patent law, for example. They'll ask the Solicitor General to file a brief, almost like an amicus brief, and so we will get involved in that case, and we'll typically meet with the parties. In fact, I'm meeting with Apple on Monday on a CDSG, and to me, I think the value that we can add, regardless of what our stake is, like, to me, we bring a lot of context that maybe the Solicitor General doesn't have. That we understand, like, I hope we understand, I certainly understand, the interplay and the practical aspects of patent litigation, and the implications of the rule that the party is advocating, and maybe that, maybe they're overplaying your hand about, how the sky is falling with if this is, this rule stands up. And so I think, to me, that's where we can bring some value, because we see, you know, the entire ecosystem, how our work product gets used out in the marketplace and what happens to it. And so, at least as I approach those cases and the folks that I work with, I want to bring that context to the Solicitor General so that they can make the most informed decision. But am I going to be able to tell, you know, the Solicitor General, like, inform him about the 7th Amendment and the right to jury? No. Like, he has forgotten more than I'll ever know about the 7th Amendment. So that's my purpose, I think, in those cases that aren't just right in our wheelhouse, whether, you know, it's KSR or Alice or whatever, you know, those, I think, you know, do implicate things that we're going to have to implement within the agency. So, you know, that we do obviously have an interest in, but when it comes to sort of infringement cases or something like that, or damages, or whatever the case may be, I want them to make an informed decision about it with all the benefit of our experience.
That's helpful, that's interesting. And since you mentioned Apple, the case I had in mind was Apple versus Qualcomm. And you know, what's interesting about that case, because, and I'm not going to push you to talk about it, is that it does strike me a little bit as that 7th Amendment, because at least the way I read Apple versus, it is primarily a case about standing. And like, I would think that the SG knows everything the SG needs to know about standing.
Yeah.
And so this sort of sense of what the context is useful. I would wonder how much the Supreme Court, is going to think about the patent-specific context when it is deciding a question of standing. But
yeah, again, like,
there may be enough there.
I don't know.
Yeah.
To answer your question, I don't know. But I know who does know, the Solicitor General.
Yeah, sure.
And so my role, I feel like, is just to equip her to make the best decision, and, you know, with all of the context that's available. At least in the patent context, you know, if there are other implications in standing outside of patent cases, you know, then hopefully there are other agencies who are bringing that context to her, and then she can assimilate all of that in forming the government's position.
Other questions? I mean, I could just keep asking questions, but I also, like, at some point you're going to get hungry. So
Let's give the people some lunch.
Yeah.
All right. Well, thank you all for having us.